Hi everyone, we have joined back again. Guys, the first impression of the paper is already discussed in previous video. So let us wait for a file so few other students can also join, and then we will start the paper solving session. In the meantime, if anyone of you wants to discuss about the paper, about the pattern, about the difficulty level, please the forum is open. Please discuss it. So it will be a two-way discussion and let's make it an interactive one. This is your paper, and students, we will be discussing with paper set D. So those who have other sets, please cross-check the questions carefully because the sets change. The question change according to the sets, right? Guys, please join fast. Yes. Just give me a thumbs up if I can be if I am audible to you all, guys. You people have appeared. Rajasthan paper पैटर्न बहुत ऊपर नीचे करा है कमीशन ने. Let's be honest with that. But a student who is thorough with the concept, जिसने अच्छे से पेयर एक्ट पढ़ी है, जिसने अच्छे से sections को पढ़ा है, so that a student can clear. But only mugging up the section number, name, titles, article, case laws won't help this time. Every new paper of judiciary, state judiciary, gives us a drastic change. It shows that it is not that easy which it used to be prior to 5 or 6 years. If we compare to this year paper to 2019 and 2021, this year the level of questions has increased immensely. I can see 7 students have joined. Guys, please give me a thumbs up if everything is fine on my side. You can see the screen and you can listen me clearly. Just give me a thumbs up so I can start the analysis session. And we will be solving the whole paper, and then we will be discussing some key points and the cutoff and everything. Guys, please give me a thumbs up so I can start ahead. In the previous video, we have already discussed how many questions were there, the difficulty level of question, the paper, everything. We will be going through that also in brief, not that detail. But if you guys permit, then I will start the paper solving session. Okay, guys, thank you. So we will be starting the paper solving session. So first question is from CPC. CPC has been in a major play this time. And the first question is, A sues B for compensation on account of trespass. B holds a promissory note for rupees 5,000 from A under Order 8 Rule 6 of the CPC to set off that amount of rupees 5,000 from any sum to be recovered from A in the suit B. The options are cannot claim because the different characters of A and B regarding payment of amount, cannot claim because as soon as A recovers, B has two different characters. Option C is can claim because as soon as A recovers, both sums are definite pecuniary demand. Option D is cannot claim because both the sums are not definite. Guys, if you want to answer this question, I will be happy. If anybody of you want to answer this question. The correct answer for this question is option C, that is can claim, because as soon as A recover the compensation of the trespass, both sums are definite pecuniary demands, not different. Then moving to question number 2. Which of the following statement is not correct regarding the notice in writing given under Section 80 of the Code of Criminal Procedure? Section 80 talks about the notice in writing. So, which of the following is not correct? So, the first option is it is necessary to state the cause of action and relief. This is the first prerequisite for a notice which is to be sent under Article Section 80, that the cause of action and relief is necessary to be stated in the notice. Second, the proper name, description, and place of the residence is also required. If the defendants are other than central government and state government, then it is necessary to state the name, description. Again, the same thing, that the name and description, place of residence should be specifically mentioned, right? And option 4, the claim can be presented after expiration of 2 months. This is not correct. Option D is correct. Right. Moving to third question. Which of the following is an illustration of Section 116 of C? What they have asked, they haven't asked about Section 16. What is the title of Section 16? What is the conceptual knowledge of Section 16? They have asked what illustration is there in Section 116 or not. So first is, just so option 1 is a lessee accept from his lessor a new lease of the property lease to take effect during the continuance of the existing lease. So this is this is not an illustration. Option B is A, the lessor gives B, the lessee, notice to quit the property lease. The notice expires, B tenders, and A accept rent which has become due in respect of property since expiration of the notice. C is A, let a farm to B for the life of C. C dies, but B continues in possession with A's assent. So if you have attended the class of Lawsikho, the faculty has specifically mentioned, then A is, after A is assent, B can continue the possession. So option C is correct. For question number 3, option C is correct. Then question number 4 is, which of the following statement is not correct? The question number 4 basically deals about deputy chairman of council of the state. So a member holding office as deputy chairman of council of the state shall vacate his office if he ceases to member of the council. So this is correct. This is correct. Whenever a member ceases to the member of the council, then he has to vacate his office of deputy chairman of the council of the state. Then second, a member holding the office of deputy chairman of the council of the state may at any time, by writing under his hand, address to the chairman. So resignation, he can offer, the deputy chairman can offer his resignation to chairman. That is also correct. Then a member holding as a deputy chairman of the council of state may be removed from his office by resolution of the council passed majority of all the then members of the council. So yes, it is necessary for removing a deputy chairman from the council of state. A majority is required to remove that deputy chairman. So this is also correct. So A is correct, B is correct, C is correct, then D is correct. Right? Option D is correct. A member, so president assent is not required for removing deputy chairman. Then question number 5, we can see that matching based question is also there. Then let's start with matching. See, all the types of questions have been asked: illustration based, conceptual based, section based are also there. So this is basically section based. This is pertaining to Limitation Act. And if you have idea about this, then if you have idea about only 2 articles of the Limitation Act, then you can do it. So correct answer for this question is option B. That is, Article 19 deals with money payable for rent. Then Article 52 deals with arrears of rent. Then Article 54 deals with specific performance of contract. and mortgage is dealt under Article 63. So option B is correct. We will be providing you the answers keys in the last as well, students. Till here, any query you guys are facing? If you want to discuss any question till here. Okay. Then question number 6 is, which is the following power is not vested in the court to which the decree was sent for execution? So whenever in CPC, when when the decree is sent to another court for execution, so that court has following powers. So we have to see which power that executing court doesn't have. So first is power to send the decree for execution to another court under section 39 of CPC. That is correct. Then power to execute the decree against the legal representative. So we have studied legal against legal representative also. Executing court can execute the decree. Third is power to order execution at the instance of transferee of the decree, and this executing court cannot do. Option C is correct. For question number 6, option 6 is C is correct. Then question number 7, which of the following cases related to ambit of judicial review in the matter of appointment of judges to High Court under Article 217 of Constitution of India? So the correct answer is C. The petitioner is same in all the options. You have to just check who is the respondent, whether it is Union of India, whether it is Supreme Court of India, President of India, or State of Kerala. So which of the correct citation is there? So question number 7, option B is correct. That is Anna Matthews versus Supreme Court of India. Then question number 8, which of the following communication is not protected for disclosure under section 126 of Indian Evidence Act? So option 1, the client says to the advocate that he has murdered A by shooting and he wishes to advocate is to defend him. So yes, it is covered under, it is basically talking about privileged communication. So option A comes under that. Then option B, the client says to his advocate that he has obtained the possession of the property on the basis of forged document and he wishes to advocate. So this is also correct. It is also a privileged communication. Then third is the client says to his advocate that he wishes to obtain possession of the property on basis of forged will on which he requests to sue. See, here is the catch, on which he requests to sue. He cannot request to sue a person on the wrong information. So option C is correct. Then question number 9, see guys, you can just see the options, how long the options are, how they have make a trick to make the paper more comprehensive rather than they make the options more detailed ones. So it will be time consuming and it didn't allow students to sit and to do a paper, while in the previous year papers student can able to solve the paper while 5 or 10 minutes, but this year as per the feedbacks which we are getting, the students have, some people have left the paper because of the less time, because they are engaged only in these long questions, right? So let's move to question number 9. Which of the following statement is not correct according to provision Rule 43 and Rule 68 of Order 21 of CPC? See, Order 21 is always a hot topic. In every exam, I can say 1 or 2 question is asked from Order 21. That's why it is a very detailed order also. And it is very necessary while studying CPC. So the correct answer for question number 9 is option 4. The sale of immovable property shall take place until after expiration of at least 1 month. The time period here is crucial, that it should be 1 month. So option D is correct. Then question number 10. Civil Procedure Code is included in which of the following list of Constitution of India? So it falls under concurrent list. It doesn't come under state list nor union list. It is, the correct answer is concurrent list. Then question number 11. In which illustration of the following illustration the surety discharged from his liability. So this question is under contract, and section 139 of contract deals with surety discharge from his liabilities. So the correct answer is option D. Just yeah, option D is correct. For question number 11, option D is correct. Then question number 12, A obtains a decree against B for rupees 25,000. C, who is a trustee for B, obtains a decree on behalf of B against A for rupees 25,000. Which of the following statement is correct with regard to above illustration? And the correct answer is B can treat C decree as a cross decree. I hope you have understand the concept of cross decree. But on the A has obtained the decree on the behalf of B against A, so that's why it is amounts to cross decree. Then question number 13 is the statutes of limitation are premised on which fundamental legal maxim? So the correct answer is A, of vigilantes non dormentibus jura subventium. Guys, pardon my pronunciation if I'm wrong, but the answer is option A. Then question number 14. Which of the following statement is correct for the purpose of section 21 of SRA? So here they haven't asked about section 21. They have asked what is the purpose of section 21. So it talks about compensation in certain cases. But here the correct answer is option B. The compensation cannot be awarded where plaintiff has not claimed compensation in the suit. Correct answer is option B. Then question number 15. Which of the following statement is not correct with regard to mortgages of immovable property and charges under the TPA 1882? So the correct answer is in simple mortgage, the possession of mortgage property is delivered, which is not required. In simple mortgage, possession is not required. So it is incorrect. The correct answer is C. Then question number 16. In which of the following judgments Honorable Supreme Court declared right to privacy? Right to privacy we have read. In which case the landmark, the case is Justice K.S. Puttaswamy versus Union of India and others. Right. Till here, guys, any problem? I can see in comment section any problem you guys are facing. Any question which you feel that answer you have marked something different and I have marked something other. So we can discuss on that. Okay, moving ahead. Question number 17 is no attachment under precept sent under section 46 of the CPC shall continue for. It is asking for the time period of a precept. So what is the time period for a precept? It is 2 months. A precept is made for 2 months. For question number 17, the answer is 2 months. Then question number 18. When specific words, it is related to interpretation of statutes. When specific words are followed by general words, the meaning of those general words should be taken in context of those specific words, and the general words should be construed as limited as the specific words. So the above rule is rule of homogeneous interpretation. Option B is correct. Guys. Yes. Option C is correct. That is rule of homogeneous interpretation. Then question number 19. In which of the following case Supreme Court held that there is no unqualified right to marriage and the same-sex couple cannot claim this as a fundamental right? So it is held in Supriya Chakravarti and others versus Union of India. Option A. Guys, only one landmark case I can see, that is the Justice K.S. Puttaswamy case. Other than that, you have to be very thorough about the concepts and case laws. It's not the easy paper. Okay, chalo. Let's move to next question. That is, the judgment debtor shall secure to the decree holder such periodical payments. The above order can be passed by court in execution of which type of decree? So the decree pertaining to restitution of conjugal rights, immovable property, execution of document, or execution of decree against him. So the correct answer is it is passed and in decree of restitution of conjugal rights. Option A is correct. Then question number 21. The first hearing of suit in CPC, what is the meaning of first hearing of the suit? So the presentation of plaint in the court? No. The presentation of written statement by the defendant? It is also not correct. The examination under Order 10 Rule 2 is correct. Right. Correct answer is option C, that is the examination under Order 10 Rule 2. Then we have seen matching based question, again a matching based question. Question number 22. And the correct answer is option 1. One is D, that is decree in administration suit. Option D. Then decree in preemption suit. Order 20 Rule 14. Then decree in suit for partition of property, Order 20 Rule 18, and decree for possession and mesne profit, Order 20 Rule 12. Moving ahead. With regard to doctrine of estoppel, which of the following statement is wrong? So the doctrine of estoppel is recognized the rule of equity. It is correct. The doctrine of estoppel deals only relating to aspect of public policy. No. It does not deals only relating to the aspect of public policy. It is wrong. So option B is correct. Then question number 24. The maxim ut res majus valeat onum varieties is also known as which rule? Rule of harmonious construction, reasonable construction, existence generis, or golden rule? The correct answer is rule of harmonious construction. See, they have asked all the minor laws in same proportion which were asked in the previous year paper. But the portion of major law subjects have been changed. That's why this paper is difficult also. Because otherwise all the acts are asked and 1 to 2 questions are asked from all the minor acts. Right? Then question number 25. A is a decree holder and B is a judgment debtor. B took loan from A. At that time, it was the condition mentioned in the agreement that all money payable under a policy of life insurance of B will also be liable to pay the amount of loan and for attachment. The correct answer is C. That is, such agreement is void ab initio. Because under Section 60 exempts insurance policies, attachment of insurance policies, Section 60. Right? So option C is correct. Then 27. In which of the following cases Supreme Court observed that presumption under Section 90 of the Indian Evidence Act with regard to genuineness and regularity of the document which are more than 30 years is inapplicable when it's come to goodwill? And the correct answer for this question is case Ashutosh Samanti by Elas and legal representative and others versus S.M. Ranjan Baladasi and others. Option B is correct. Then question number 27. Which of the following statement is correct with reference to question under High Court under? It is asking about Order 46 Rule 1 about the High Court order of reference. So after making the reference, the court who made the reference will not proceed the case until the receipt of the copy of the judgment of High Court upon the reference. No. After making the reference, the court who made the reference can proceed. Here, not word is included, but here can proceed in case and may pass a decree contingent upon the decision of the High Court on point referred. Correct answer is option B. Then next. Okay, here is a Rent Control Act, that is Rajasthan Rent Control Act. So the agreement executed on 1/1/2024 between landlord and the tenant to increase the rent of the let out premises by 4% per annum. Under Section 27, under Section 7 of the Rajasthan Rent Control Act, such agreement is lawful because under Section 7, till the increment of 5%, no agreement is required. So here it is 4% per annum only. And in Section 7, 5% is allowed. So it is lawful. Then question number 29. A law made by one legislature affect the scope of other legislature in a related manner, then which of the following doctrine of interpretation is applied? So we have read this in Constitution as well. That is doctrine of colorable legislation, in which one pillar of democracy tried to encroach on another pillar of democracy through making some act which it cannot be do directly but indirectly. Right. So correct answer is doctrine of colorable legislation. Then question number 30. Which of the following is not correct under provision of TPA 1882? First is an interest in property restricted in its enjoyment to the owner personally can be transferred to by him. Instrument means non-testamentary instrument. It is correct. An easement cannot be transferred apart from dominant heritage. It is also correct. A transfer of property may be made without writing in every case in which a writing is not expressly required by law. Is not expressly required by law. This is also correct. Option 1 is wrong, hence it is correct. Then 31. Under Section 20, Clause 3 of Rent Control Act, mesne profit denotes rent as fee. First of all, we have read mesne profit in CPC as well. So it is basically used for making the owner of the property to get a particular amount which he is deprived because the respondent was using his property unauthorized. So the certain amount of money which a owner can earn, but because of unauthorized use by a respondent, they are deprived of. So that is basically a mesne profit. So let's read the option now. Rent as agreed as envisaged under Section 4 of the Act? No. Compensation depriving landlord? See, this is the correct answer. Compensation depriving landlord from the use of the premises. Option B is correct. Then question number 32. In which order of the code of CPC under the expression decree includes the final order? Correct answer is order 45. If you read order 45, rule 1, it is mentioned that decree means final order. Decree means final order in under order 45, rule 1. Then Article 39A, everyone knows what is Article 39A. So it is equal pay for equal justice and free legal aid service. Option B is correct. Question number 33, option 2 is correct. Then question number 34. The object behind the oral examination of parties under Order 10 Rule 2 of CPC is to elucidate matter in controversy, to pre-examine the witness, to find out issue of facts and law, to find out admitted facts. No, the correct answer is option 1, that is to elucidate matters in controversy. Then question number 35. Which of the following is not an appealable order? So order under Rule 31, Order 21 is appealable. Rule 10, Order 22 is appealable. Rule 2 Order 25 is applicable. So correct answer is option B, that is Rule 17 Order 6, which is not applicable. Then question number 36. Ramlal purchases a motorcycle and get it insured. Thereafter, he causes to same cast away with the intention of causing damages to insurance company. Which offense Ramlal has committed? Is it mischief, cheating, criminal misappropriation, criminal breach of trust? The correct answer is mischief. Question number 36, option A is correct. Then question 37. Who among the following does not include in the definition of domestic worker under Sexual Harassment Act? So worker employed on temporary basis, no, it is included. Woman employed on permanent basis, it is also included. Women employed on part-time basis, all three are included. Option D is correct. Family member is not included. Then question number 38. Which of the following does not come under the exception of the offenses of defamation? So truth, here it is asking not. So truth is an exception. Public conduct of public servant is an exception. If something which is decided on merit of cases by the courts and conducted business and other consent, it is also correct. Censure passed in good faith by the person not having lawfully authority over another, because he has not having lawful authority. Because if he has lawful authority, then it will fall under option 2, that is public conduct by public servants. So correct answer is option D. Question number 38, option D is correct. Then just look at this passage, guys. There was an argument between Ramesh and Suresh over some issue. Ramesh started abusing Suresh badly, which causes sudden grave and provocation. We will highlight the words as well. Sudden grave and provocation to Suresh. Suresh had a stick lies beside him. Under the effect of sudden, again, they are also highlighting that under the effect of sudden grave and provocation, he picked up the stick with his right hand. Vijay, who has an old enmity with Ramesh, wants to kill Ramesh at any cost, was standing nearby and watching all this. He suddenly reached there and says to Suresh, "What kind of person you are? You are standing and listening to abuse against your mother and sister. The stick is not going to do anything. Take this revolver." And saying this, he hands over the revolver to Suresh, and Suresh takes the revolver and fire at Ramesh, which causes Ramesh death. What offenses has Suresh and Vijay committed? So both have committed culpable homicide? No. Suresh has committed offense of murder and Vijay has committed offense of culpable homicide not amounting to murder. Vijay has committed murder and Suresh has committed the offense of culpable homicide not amounting to murder. Option C is correct. Then question number 40. While committing any case exclusively triable by court of session, magistrate shall remand the accused for how much period? For 15 days, until the date of framing of charge by court of session, during and until the conclusion of trial, and remaining period of 60 and 90 days, the case may be as prescribed under section 167 of the CRPC. So it is correct. Then question number 41. Under the JJ Act, which of the following statement is in relation with the eligibility of prospective adoptive parents? The prospective adoptive parents means physically fit, financially sound, mentally alert, and highly motivated to adopt a child for providing a good upbringing to him. In case of couple, the consent of both the spouses for the adoption shall be required. A single male is eligible to adopt a girl child. A single or divorced person can also adopt, subject to fulfillment of the criteria and in accordance with the provision of the adoption regulation framed by the authorities. So they are asking what is wrong in relation. So a single male is not eligible to adopt a girl child. Option C is correct. Then question number 42. Who among the following is not competent to conduct investigation? See, here they are asking, we have read three things, that is investigation, then inquiry, and then trial. So SHO or of a police station, he can conduct. A magistrate, can a magistrate conduct an investigation? Let's read the next option as well. Any person other than magistrate who is authorized by a magistrate in this behalf. This is also correct. Director General of Police of the state. This is also correct. So option 2 is correct. A magistrate is not competent to conduct an investigation. Then question number 43. Under Section 33 of Evidence Act, a criminal trial regarding relevancy of certain evidence for proving in subsequent proceeding truth of facts therein stated shall be deemed to be a proceeding between complainant and the accused, prosecutor and the accused, witness produced for the complainant and the accused, all of the above. So option C is correct. Proceeding between witness produced for the complainant and the accused. Then question number 44. When one fact is declared by Indian Evidence Act to be conclusive proof of the other, the court shall, on disapproving one fact, regard the other fact as proved and shall not allow evidence to be given for the purpose of disproving it. No. They are asking about conclusive proof. Shall, on proof of one fact, regard the other as proved and shall not allow evidence to be given for the purpose of disproving it. This is far better answer, but let's read to next two options as well. Shall, on proof of one fact, regard to other as proved and shall allow evidence. No, court won't allow evidence. Shall, on proof of one fact, regard the other as disproved. No. So the correct answer is option 2. Then question number 45. Accused prays before the court to see the report of probation officer made under section 4 clause 2 and 6 clause 2 of Probation Offenders Act. In this regard, which of the statement is correct? The correct answer is option C. That is, such a report is confidential document, although the court may, if it so think fit, communicate the substance thereof to the accused. Option C is correct. For question number 45, option C is correct. Then question number 46. Ram Swarup is charged and convicted for the theft of golden chain of Savita. Which of the following statement is correct regarding above illustration? Ram Swarup can subsequently charged with and tried for robbery of the same fact. Right. Ram Swarup can neither subsequently charged nor tried for robbery. No. However, Ram Swarup can subsequently charge for robbery on same facts but shall be acquitted without trial as per the provisions under section 300 of CRPC after getting prior permission writing from session judge concerned. Only thereafter Ram Swarup can subsequently. No. The correct answer is option A. Sorry, option C. Ram Swarup can subsequently be charged for robbery on same facts but shall be acquitted without trial as per provision under section 300 of CRPC. Option C is correct. Then question number 47. Distribution of which of the following samples under indecent representation of women acts come under definition of distribution? So the correct answer is distribution by the way of sample, whether free or otherwise. It can be any means. So it can be free or otherwise. Then question number 48. Which of the following case cannot be tried summarily under the provision of the Code of Criminal Procedure, Code 1973? So it can be offences under punishable death for term of 2 years. It can be offences punishable under section 454. It can be offence punishable under section 114 of IPC, where the value of property concealed is 5,000. Right. So correct answer is option C. Then 49 question is, who among the following is not entitled to get maintenance under 125 of CRPC? Wife is entitled. Illegitimate minor child is also entitled. Mother or father is also entitled. Married daughter who has attained majority by reason of physical and mental abnormality or injury unable to maintain herself, she cannot claim. Option 4 is correct. Then 50. In order to commit theft, Vinay put his hand in his pocket of Dinesh but came to know Dinesh's pocket is empty. What offense Vinay committed? Vinay has committed offense of attempt to theft because he has pure intention to commit theft, but there is nothing, so that is only attempt to theft. Guys, we are done with half paper. Till here, any discrepancy, any issue, any question you want to ask? Yeah, I can see many hand raises here. But till here, any other any problems which you are facing? We are done with half paper. Anyone, guys? Okay, thank you. Then question number 51. Which of the following is such an offense if commission thereof will be the object of the assembly? So, and then it does not come under purview of unlawful assembly. Basically, it is talking about. So, the options are to overview by criminal force any public servant to exercise his lawful duty, to resist the execution of legal process, to commit criminal trespass, or to commit cheating. It is to commit cheating. Then question number 52. Chetna and Vijay work in similar office. Chetna find a government promissory note belonging to Vijayta bearing a blank endorsement. Chetna, knowing that the note belongs to Vijayta, pledged it with a banker as a security for a loan, intending at a future time to restore it to Vijayta. Which of the following statement is correct? Chetna has not committed any offense, so she has committed offense. Chetna has committed the offense of dishonest misappropriation because she has used the promissory note for her own well-being. Right? So option B is correct. Then question number 53. In which of the following circumstances a private person can also arrest? Section 42 of CRPC. So the correct answer is option C. That is when such person commits a non-bailable and cognizable offense in his presence. Then question number 54. In which of the following cases Supreme Court held that marriage death of the deceased being unnatural in the matrimonial home within 7 years of marriage will not be sufficient to convict the accused under Section 304B and 498A of IPC? So the correct answer is Charan Singh versus State of Uttarakhand. Then next, question number 55. Under the JJ Act, aftercare means provision of support, financial and otherwise, to person who dash and has left any institutional care to join the mainstream of the society. The correct answer is the age of 21 years. Who has not completed the age of 21 years. Then question number 56. Which of the following is not essential ingredients of theft? So see, this question is such nature that anybody can attempt it. The questions like this are also there, but it is very few. So the correct answer is in theft, dishonest intention is required, movable property is required, property in possession of the owner is also required, but fear of causing injury is not required. So option D is correct. Then question number 57. Hariom is sentenced for an offense of theft for simple imprisonment of 2 years and a fine of 500. In default of payment of fine, he is ordered to undergo further imprisonment for a period of 1 month. Just a minute, guys. So sorry for the inconvenience, guys. In default of, coming back to question number 57. In default of payment of fine, he is ordered to undergo further imprisonment for a period of 1 month. During imprisonment of 2 years, Hariom died due to some illness, and Hariom is only having house of his sole ownership. Which of the following statement is correct regards to recovery of payment of fine? So, due to death of Hariom, he is discharged from the liability of fine. No. Amount of fine shall be recovered from his house. It can be. Let's move to the next option. It is a matter of discretion of the court. Court can discharge from liability or can recover the amount of fine from his house. Payment of fine cannot be recovered from his home, although if court desires, then such fine can order to recover from his legal representative. Option D is correct. Then question number 58. Under POXO Act, the special court from taking the cognizance is the evidence of the child shall be recorded within 30 days and the trial shall be completed within 1 year. So time period is different on all the options. So let's find out the correct time period. So the correct time period is 30 days. Option 1 is correct. The time period is 30 days and the trial should be completed in 1 year. Then question number 59. Which option is correct with relation to the proceeding conducted in camera under DV Act? So there is a special provision for the recording of the proceeding through camera. So the correct answer is that option C. This is question of the discretion of the court. If magistrate thinks fit that it is necessary, then proceeding may be conducted in camera. Option 1 is not correct because all the proceeding is not required. This option B is this statement is not correct. All the proceeding must be conducted in open court. No. Then option C is correct. If the court or magistrate desires, then only the proceeding can be done in camera. Then question number 60. The Sarpanch of village Mohan was being tried for rape with the secretary of village assembly Savita. A question is asked to Savita during cross-examination that did she warrantly have illicit relationship with ex-Sarpanch Amit. Such question is permissible, not permissible with prior permission of public prosecutor, permissible with prior written permission of ex-Sarpanch Amit, not permissible. It is not permissible. Option D is correct. Then question number 61. Search warrant under section 94 of CRPC can be issued by DM or session judge, CJM or session judge, DM, JMFC or Tehsildar, DM, SDM or magistrate of first class. So the correct answer is option D. Then offense of breach of protection order passed by DV Act is option C is correct. That is cognizable and non-bailable. That's why it is making the DV Act more rigid and stringent. Then question number 63. Court issue a non-bailable warrant under section 70 of CRPC in a matter. Such warrant shall remain in force for how many days? So it is till it is cancelled by the court which issued it or it is executed. Then question number 64 is, in which of the following matters section 306 of Criminal Procedure Code does not apply? So in which matters? So any offence triable exclusively by court of session, offence punishable with imprisonment of 3 years, any offence triable exclusively by court of special judge appointed under Criminal Law Amendment Act, any offence punishable with imprisonment which may extend to 7 years. So the correct answer is option B, that is offence punishable with imprisonment of 3 years. Then question number 65. Suresh, Ramesh and Jagdish are kept in judicial custody in a house declared as jail under special circumstances. There are stern guard of armed force around the house. Jagdish is murdered, for which Suresh and Ramesh are prosecuted. Direct evidence of murder is not found. Prosecution wants to prove that entry of anybody was not possible due to guards of armed force, and commission of murder of Jagdish was not possible by anybody else than Suresh and Ramesh. This fact is relevant, irrelevant, neither relevant nor irrelevant, a conclusive proof. It is relevant. We have read last seen theory in Evidence Act. So this is pertaining to that last seen theory. Then 66. There is an old rivalry between Rachit and Vikas. Vikas goes to Rachit's house with an automatic pistol to kill him. On reaching there, he puts the pistol on his head and says, "You have troubled me a lot. Today your life will end." Rachit suddenly snatched the pistol from Vikas' hand, upon which Vikas immediately start running from there. While running, Rachit fired several rounds of pistol at Vikas, due to which he dies on the spot. What offense has Rachit committed? So Rachit has self-defended him, therefore has not committed. See, self-defense is not here because Vikas immediately start running from away there. He is not making any threat or danger more to the person. He start running away. So self-defense is not come into the picture. Then option 2 is Rachit has committed the offense of culpable homicide amounting to murder. Option B is correct. Then question number 67. Under the Negotiable Instrument Act, director in relation to a firm means? It means a partner in the firm. Question number 67, option A is correct. Under POXO Act, question number 68, under POXO Act, the magistrate or the police officer, as the case may be, shall record the statement as spoken by child in presence of whom? A special public prosecutor, reader of the court, member of child welfare committee, parent of the child, or any other person in whom the child has trust or confidence. Option D is correct. Then question number 70. For the purpose of making an inquiry under subsection 1 of section 11 of Sexual Harassment Act, the internal committee shall have same power of summoning of any person and examining him on oath as vested in civil court under CPC, vested in civil court under Indian Evidence Act, vested in criminal court under Code of Criminal Procedure, vested in criminal court under Indian Evidence Act. So the correct answer is vested in civil court under the Code of Civil Procedure. So guys, we are done with law portion. 70 questions are done. Now we are moving ahead to Hindi and English portion. Please let me know till here any queries you guys have. I know many of you are just traveling back to your rooms, hotels, wherever you stay. So this is quite hectic, but please bear with that and let us know if you have faced any problem in that. Right? Okay. Then first question of Hindi is अशुद्ध शब्द है, इनमें से कौन सा शब्द अशुद्ध है? अभ्यर्थी, स्वतंत्र, निरपराध, उच्छ्वास. So the correct answer is अभ्यर्थी. Then question number 72. पारिभाषिकता की दृष्टि से सुमेलन नहीं है. पारिभाषिकता की दृष्टि से सुमेलन नहीं है. विधिमान, वैलिड, विधिपूर्वक, लॉफुली, विधिपूर्ण, वैलिडेट, विधि सम्मत, लेजिटिमेट. So the correct answer is option B. विधिपूर्वक means lawfully. It is विधिपूर्ण means validate. Option C is correct. Then अपने आप को स्वयं मारने वाला वाक्यांश हेतु उपयुक्त शब्द है. In English we say it one word substitution. So the correct answer is आत्मघाती. Then question number 74. संज्ञा से बनने वाला क्रिया रूप नहीं है. The correct answer is अपनाना. Option 2 is correct. Then question number 75. तत्सम शब्द नहीं है. चीता is not a तत्सम शब्द. Then बहुवचन में यथावत प्रयोग हेतु उपयुक्त शब्द वाला विकल्प है. प्राण. The correct option is option B, that is प्राण. Then question number 77. उपयुक्त विलोमता वाले विकल्प नहीं है. असूया, अनसूया, अनिवार्य, निवार्य, अभिज्ञ, भिज्ञ, आद्र, अनाद्र. The correct answer is अभिज्ञ, भिज्ञ. Then question number 78. किस विकल्प के सभी शब्द पुल्लिंग है? The correct answer is option 1, that is gulab seb sharbat. Then question number 79, इन प्रत्यय से निर्मित शब्द नहीं है. The correct answer is option D, that is प्रवीण. Then question number 80, शुद्ध वाक्य है, इनमें से कौन सा वाक्य शुद्ध है? ऑप्शन 4 is correct, that is राष्ट्र की उन्नति और शक्ति उसकी एकता पर निर्भर है. Then question number 81, विस्मय आदि बोधक चिन्ह के अशुद्ध प्रयोग वाला विकल्प है. ऑप्शन डी, दैट इज वाह कितने अच्छा गीत गाया तुमने. क्वेश्चन नंबर 82, अनु उपसर्ग से निर्मित शब्द नहीं है, इनमें से कौन से शब्द है जो अनु उपसर्ग से निर्मित नहीं है? तो करेक्ट आंसर इज अनुपस्थिति. देन क्वेश्चन नंबर 83, दाल में कुछ गिर गया है, वाक्य में कुछ शब्द में सर्वनाम का प्रकार है, कौन सा प्रकार है? दैट इज अनिश्चयवाचक. ऑप्शन ए इज करेक्ट. देन व्यंजन संधि से निर्मित शब्द रूप नहीं है, दैट इज समुदोर्मी. ऑप्शन 84, ऑप्शन डी इज करेक्ट. Guys, there is a change in option for question number 81. In 81, option C is correct. भगवान तुम्हारा भला करे. Question number 81, option C is correct. That is भगवान तुम्हारा भला करे. Then coming to last question of Hindi portion, that is दमड़ी की सुर्द सवा मन मलिदा लोकोक्ति का निकटतम अर्थ है. The correct answer is थोड़े से लाभ के लिए बहुत अधिक खर्चा करना. So Hindi is also this time a bit higher level of question is asked in Hindi as well. It is not same as past year papers. Then coming to English portion, passive voice of we ought to clean our surrounding clean. The correct answer is our surrounding ought to be kept clean. Then question number 87, I will punish you. Option B is correct. Then 88, tell me where you live. In this given sentence, noun clause is used as object of transitive verb. Then 89, he dashed in his father farm till his father died. So the correct answer is option D, that is stayed. He stayed in his father farm till his father died. Then question 90, the Economist is dash magazine and the zero article. The correct answer is a magazine. Then synonym of impeccable is, impeccable means flawless. Then 92, dash of the staff can speak Japanese, some of the staff. We have to fill article or determiner. So correct answer is answer option 2. Then question number 93 is dash beauty of Cleopatra is famous all over the world. The correct answer is the beauty of Cleopatra is famous all over the world. Then question number 94, the antonym of word prospect is retrospect. 95, the builders say they will have finished the roof by Tuesday. Option B is correct. 96 question, we have to choose which of the following is correct indirect transformation of the sentence given below. He said, alas, I have lost my mobile phone. So the correct answer is option C, that is he exclaimed with sorrow that he had lost his mobile phone. Then question 97, my plans to go Germany fell through because the journey turned out to be very exorbitant. Option B is correct. Then question 98, I dash all my childhood in Denmark. Had spending, will have spent, will spending, spent. The correct answer is spent. Then 99, he always run down his rival. Option A is correct. And last question for the day, but not the least. Choose the correct passive transformation. We have already given him a notice to vacate our house. The correct answer is option 1. That is, he has already been given a notice to vacate our house. Correct answer is option A. Guys, we are done with the paper solving. Till here, if anyone of you have any problem, any confusion in that, please share with us. So we can discuss on that, and let's be clear with all the question and answers. Seema, Nishita, Manasvi, anybody or any one of you want to say something? Guys, just you have to comment it down. So then we will talk about the expected cutoff. Cutoff will be ranging around, I would say, the paper is quite difficult. It is more than moderate. So cutoff will be around 68 to somehow 72. And guys, one more interesting thing is that Lawsikho has offered a test series, a comprehensive test series for you guys in just 1 rupee. So in that, the team is collating the data, and till now we have reached 45% of the questions are asked from our test series. No negative marking questions. Nishita, are you clear that there is no negative marking? Have you answered all the questions? Nishita, may I know your scores as well? Have you counted with us? Okay, please check and then let us know. So, the Lawsikho has given you test series of around 22 mocks, subject-wise mocks, and around 5 test series, 5 full-length mocks. That too in a cost of rupees 1 only. And in that questions, around till now, team has collated around 45% of the questions of today's paper is asked from our test series. The data is still compiling on. This figure will, I definitely, I have full faith in my team that this data will definitely go upwards. But as of now, it is 45%. Okay, Nishita, you are in third year of the LLB and you want to know the level of examination. So level of the examination this time it is increased immensely, I would say. It has the questions were quite moderate to tough. There are few easy question also, but barring that, it will be around. Yeah, the paper is all about. It is difficult one. Official answer key, Dipti. Official answer key will be released within a week, I guess, not more than that. And cutoff will be around for unreserved category. It will be 68 to 72 around. In 2021 also it was around 72. So this time also it will be around 68 to 72. It won't be increased because the number of participants this time has more and the vacancies are also more. So the cutoff will won't fall down. Adipti, may I know what is the total score you are getting if you have cross-checked your answers? And how did you feel? How did you see the paper? Whether it is moderate? What is your experience through this paper? Diti, I am waiting for your answer. If you are comfortable, just share it. That. Okay, 72. Yeah, you are near about the cutoff, Diti. You can start preparing for mains. Lawsikho is also tailoring a test series for mains examination as well. Just take a rest of 1 or 2 days because Rajasthan High Court is very efficient. They won't be giving you much time for mains. Hardly 1 month or 1.5 months will be there. So you can start your preparation for mains if you are scoring more than 65 or 70 marks, I can say. Right. Okay, guys, then let's connect again with the new exam, whichever is approaching. So, okay, Deepthi, no issues. Your sister gave it, and it's very kind of you that you are helping your sister in all the possible ways. So, your sister will be really proud of you the way you are helping. Okay, guys, then let's sign it off for the today. All the best for your prelims result, and we will meet again for any other upcoming exam notification. Right? Okay, guys.